Hello everyone, welcome back to Strive IS. In this video series, we are dealing with the past 1 to 1.5 years of current affairs, the topics and the background. This series will provide you for detailed and crisp analysis done by subject experts and it will help you excel in your upcoming prelims 2025. Today we are having the fourth lecture of Polity current affairs. So let us begin. Today we are starting with the topic important acts and bills. The first subtopic for today is the Epidemic Diseases Act 1897. So, what was the genesis of this particular act? The British government introduced EDA to tackle the epidemic of bubonic plague in the erstwhile Bombay Presidency in 1896, when Lord Elgin II was the viceroy. So, it is a colonial era law. Why was it in news? Because the government is trying to get a new act, a public health act, which will replace this particular colonial era act. So under this, what are the powers to the government? This act grants extensive powers to the government to regulate, prevent and control the dangerous epidemic diseases. It allows the central government to inspect ships and vessels departing from or arriving at ports within its jurisdiction. It provides punishment. Violation of the act may result in a fine of up to rupees 1000 or an imprisonment of up to 6 months under the section 188 of the Indian Penal Code 1860. According to the 2020 amendment, the Epidemic Diseases Act 2020 was enacted to stop the violence faced by healthcare workers during the pandemic. So this was done during the COVID-19 phase. So what is the International Health Regulation IHR with regards to the Epidemic Act? It was adopted by the World Health Assembly in 1969 and revised in 2005. It is an overarching legal framework for public health events and emergencies that have the potential to cross borders. It is legally binding on 196 countries, including the 194 WHO member states. It creates rights and obligations for countries, including the requirement to report public health events. It outlines the criteria to determine whether or not a particular event constitutes a public health emergency of international concern. So, this is basically for the international purposes, like we saw in the COVID-19 case. We saw purpose. Okay, during the COVID-19, we saw it emerged in one particular country. So it was a, but then it started, it started passing everywhere because of the travel and everything. So that was a public health emergency of international concern. So according to the IHR, it was declared as such. So what is the definition of pandemic and its developmental stages? So first of all, we deal with the outbreak. Outbreak is sudden occurrence of an infectious disease limited to a localized area, having the potential result in an epidemic. Then we have the epidemic. It is an infectious disease or anything resembling a disease, cause of which is unknown, resulting in widespread and rapid transmission to other people in excess of normal expectancy. Then pandemic is the one that spreads widely and could seriously harm people internationally. So outbreak, this is in terms of area. So outbreak is in a smaller area. Then after outbreak, we have the epidemic. Epidemic is in a larger area, but it is still, it is not international. It is still in the national boundary. And then we have the pandemic, which is larger area, and it has potential to also go in international borders. Okay, so why is this important? Because UPSC has a knack of asking outdated laws and the laws being replaced. Okay, so that's why this is important. What to study next is the DM Act 2005 and the National Health Mission. So this constitute important part of your prelims preparation. Let us begin with the next topic. Rights of Persons with Disability, RPWD Act 2016. So according to this, what are the different features? In terms of education, free education between the ages of 16 to 18 years, and at least 5% reservation in government and government aided higher educational institutions. Then in case of employment, at least 4% reservation in government jobs. Age relaxation could also be allowed. Government may exempt any government establishment from this provision, so the exception also can be decided by the government. Then what are the incentives to the private sector? Government may incentivize private sector to ensure that at least 5% of their workforce constitute PWDs. So what are the kind of incentives that are given to the PWD, people with disabilities? Then high support, provision for high support to person with a benchmark disability who needs it. Then what are the other provisions in the act for effective implementation? Like financial support, creation of national and state funds to support PWDs financially. Then we have the chief commissioner and commissioners to be appointed at the central and state level. They are mandated to take steps, including suo moto, matlab on their own, to safeguard the rights of the PWDs. Also, we have the advisory boards. Establishment of central and state advisory boards on disability as policy making bodies. We have regulatory bodies, we have special courts and penalties. So provision for fine for breaching any of the provisions of this act. What are the different schemes for the PWDs? Social empowerment ke liye we have the Accessible India campaign, unique disability identification project. Then for physical empowerment, we have the assistance to disabled persons for purchase, fitting of aids, assistive devices. Economic ke liye we have the National Action Plan for skill training of persons with disabilities, concessional loan. For educational, we have scholarships and Deen Dayal Disability Rehabilitation Scheme. So why is it important? Because UPSC asks about welfare acts for vulnerable groups. Okay, and in 2018 also they had asked about the key features of the RPWD Act. Okay, so you could get this particular question as how many disabilities are recognized under the RPWD Act. So the answer to this is 21 disabilities. Okay, so what else becomes important with this is the RPWD Act itself. Article 41, which talks about the right to work and public assistance. Okay, so this forms the important part of your prelims preparation. Let us go to the next subtopic. New criminal laws come into effect from July 1. So the three criminal laws were passed by Parliament in 2023. Also, the section 1062 of the Bharatiya Nyaya Samhita, which is the new act, which provides for punishment in hit and run cases, has been put on hold because it saw a severe riots and protests from the truck drivers. That's why that is put on hold. So what are these new acts? The Bharatiya Nyaya Samhita, replacing the IPC code 1860. So these were all colonial laws. So they were outdated. So that's why they are being replaced. So what are the major points of difference? Community services for petty offenses, such as including attempted suicide to obstruct public servants' duties. So for this kind of petty offense, instead of giving them a major punishment, community service is given. Something doing something for the community, like sometimes cleaning and everything. Those things can be included. Sexual acts against women under 18 are classified as rape, regardless of consent. Terrorist act is defined as a separate offense. Then we have the Bharatiya Nagrik Suraksha Sanhita 2023, which replaces the CRPC code of 1973. What are the major points of distinction? Detention of under trials. Accused detained for half the maximum sentence must be released on bond except for death penalty or life imprisonment cases, or those with multiple pending charges. Signatures and finger impressions. Magistrate of the first class can order an accused person to give a specimen of signatures or finger impressions or handwriting or voice sample. So magistrate can do this in this case. And which is the third law? The Bharatiya Saksha Adhiniyam 2023, which replaces the Indian Evidence Act of 1872. So what are the major points here? Electronic and digital records are granted equal legal status as paper documents. So earlier, these were not held as proper evidences. So now they are held as that. Oral evidence comprises all statements, including electronic ones, permitted or required by court from witnesses regarding the matters under inquiry. Okay, so why was this necessary? What was the significance? Because it is reformative justice. It's just community service instead of imprisonment. So if you give somebody community service, it is a kind of improvement. You are going towards improvement, but imprisonment is a little harsh on petty offenses. Modernizing the justice system. For example, the IPC 1860 is outdated and does not reflect current norms of criminal jurisprudence. Then we have seamless flow of information. Okay, so why is this important for prelims? Because major law reforms play a very major role in exams. So law reforms, they form a major part of your prelims preparation. What you have to study more is about the FIR and bails. Okay, how are they different? Then, like already said about the digital evidences. Okay, let us move on to the next topic now. Telecommunications Act, Communications Act 2023. So this particular act, it replaces the Indian Telegraph Act of 1885 and Indian Wireless Telegraphy Act of 1933, owing to huge technical advancements in telecom sector and technologies. So again, the case of outdated colonial laws. So what are the salient features of the act that comes into force? The new act is that it defines various terminologies like telecommunication, spectrum user, etc. So thereby reducing uncertainties and improving investor confidence and ease of doing business. So earlier these things were not defined, and something that is not defined is, it becomes open ended, right? So there is no, if something is not defined, it becomes open ended and it is open to interpretation. So there is no confidence of the investors, or whatever, who people who are interested are not they don't have that kind of confidence. So now it it increases the confidence of the investors. Then secondly, we have right of way framework, which shall be granted on a non-discriminatory and non-exclusive basis. Then we have the central government may notify standards and conformity assessment measures for telecommunication services, network security, distribution, and everything. So central government may notify the standards. So again, it is building standards. Then we have protection of users by central government, which includes prior consent to receive specified messages like advertising messages, creation of do not disturb registers, and etc. Okay, so we see a lot of promotional ads coming up, sponsorships coming up. So for that also, we have prior consent wherein the user can, they can create the do not disturb registers and everything. Expand scope of universal service obligation fund, which will now become Digital Bharat Nidhi under the control of central government. This fund can be used to support research and development of telecommunication services, technologies, product, and pilot projects. Okay, so why is it important? Because it talks about digital governance, cyber laws. Okay, the UPSC has asked about DigiLocker, right? And data privacy, the digital key, private key, public key, all of those things. Okay. So here, what else becomes important, guys? IT Act. Also the DPDP Act. Okay. Let us move on to the next subtopic. So the next topic is Supreme Court's judgment on mineral taxation. So the Supreme Court's Constitution Bench has said that states have power to levy taxes on mineral rights. Supreme Court has held that power of legislatures to tax mining lands is not limited by the Parliament's Mines and Minerals Development and Regulation or the MMDRA Act. So basically what the Supreme Court has said is that the tax collection on mines, this power lies with the state government. The key observations by Supreme Court is that power to tax mineral rights is enumerated in the entry 50 of list 2, which is the state list, and Parliament cannot use its residuary power with respect to that subject matter. So why is it with the states? Because it lies in the list 2 of the state list. Okay, and entry 50. And the union's power of minerals is regulatory. So the center has power, but it is only regulatory in nature. They can make regulations, but the tax collection lies solely with the state government. And also they have mentioned that the term land in entry 49 of the list 2 includes mineral bearing lands, granting the states the competence to tax such lands. Court overruled its 1989 judgment that held that royalty is not within the nature of a tax and did not come under MMRDA. So what is MMRDA? MMRDA regulates the mining sector in India, and it provides for the following type of licenses. So these kind of licenses are given under MMRDA. What is important for you guys, because UPSC asks on about center state jurisdiction in tax collection, so that's why it is important. Also we saw a similar kind of question in previous years questions, so that's why it is important. What else becomes important? What else you can study is the Article 246, the seventh schedule, and the union and state relationship with respect to taxation. We have done this in previous classes. I hope that you remember. If you've not watched, then please go and watch. We've done a lot about the relationship constitutionally. Okay, so this is an important part of your prelims prep. Next, Boilers Bill 2024 introduced in Rajya Sabha. So why is it in news? Because the Boilers Bill 2024 that seeks to replace the 1923 Boilers Act. So again, an obsolete act, outdated act has been replaced, bringing in third-party certification and a risk-based inspection system. So what is new in this particular act is that we are having a third-party certification system. So earlier, see, Boilers Bill, this Boilers Act, what it does is, conventionally, Boilers Act does regulations with respect to safety, inspection, and certification of boilers, okay, that are used in industries. So earlier, who used to do this? The executives, okay, basically the bureaucracy. Bureaucracy used to do this earlier. So with the new bill that has been brought, what is changed is that now we have third-party certification. Okay, so what are the key features of this bill? That third parties certification will allow private sector entities to inspect and certify boilers. Okay, with private sector being involved, you can also see expertise. Okay, they bring in their expertise. Also, there is a mandatory risk-based inspection system to ensure safety and efficiency of boiler operations. Provision for penalties in case of non-compliance with safety regulations. Okay, why is this important again, guys? Because industrial safety and labor laws play an important role in our prelims. Okay, we have seen in 2016 there was a question on factoring act. Okay, so that's why it forms an important part. The next subtopic is Bharatiya Vayuyan Vidheyak 2024. So what is this new bill about? Is that it reforms air safety and it reforms air management and licensing rules. It also enhances passenger rights. So this particular act, it replaces the Aircraft Act of 1934. So again, it is outdated. So that's why we brought this new act. So what it does is modernizes India's aviation sector with global standards. What global standards are we talking about here? Is ICAO. So ICAO has laid down some foundational principles and we want our act to be compliant with that. That's why we are getting a new act. So now what reforms has been happened is that this new act, it transfers the licensing powers to DGCA for streamlined processes. What is the DGCA, guys? It is the Director General of Civil Aviation. Okay, it also introduces discretionary penalties and civil adjudication mechanisms for non-compliance. Okay, with this, what else becomes important is because it was also asked in your previous year question. Okay, 2021 May, it was asked about Chicago Convention. What is the Chicago Convention? ICAO is also known as the Chicago Convention. So this becomes important. You have to read about the Chicago Convention. What else can you read? Our domestic schemes, जैसे उड़ान scheme. Okay, India's aviation policy. Gagan navigation systems, Digi Yatra. All these things form important part of your prelims prep. Okay, let us move on to the next subtopic. Street Vendors, Protection of Livelihood and Regulation of Street Vending Act 2014. So why was it in news? Because there has been a highlight of that this particular act has been slowly implemented by the Ministry of Housing and Urban Affairs. So this falls under Ministry of Housing and Urban Affairs. So we see that it is not full-fledgedly implemented. Also, the Paisa portal and the PM Swanidhi Mission Monitoring Portal to track the PM Swanidhi scheme has been done under this. So what are the key features of this act? So under this act, the street vendors, okay, street vendors are basically people who sell things on the street. So they have certain rights and they have certain duties. So what are the rights of the street vendors? That vendors have the right to carry out business as per the terms in the certificate of vending. Okay, so under this act, the street vendors get a certificate. It is called a certificate of vending. In that, they have certain terms, okay, which specify how they can carry out their business. Okay, we see the rights. So what are the duties of the vendor? So the duties are to remove goods after vending period. Okay, maintain cleanliness, hygiene and civic amenities and pay maintenance charges. Under this act, we also have something called as the town vending committees. So what are these? These are committees which has 40% street vendors and 1/3 of women. And the responsibility is that identifying and allocating vending zones. So every 5 years, there is a survey of the COVs done. Sorry, I just had to run a little. So every 5 years, we have a survey of the issuing of COVs, whether they are still compliant or not. And also there is a ceiling on vendors. What is the ceiling? That the vendors can be just 2.5% of the population of a ward or town. Suppose in a town, there are 100 people living. So according to this, the people who can be vendors are just 2.5. Okay, so this is not correct. So I mean, how can there be 2.5%? So let us assume 1,000. In a town where 1,000 people live, 25 of them can be vendors. Okay, they also have grievance redressal committees. And in case of the release of seized goods, suppose the street vendors are not complying with the law, they are not abiding, then the authorities can seize their goods. But they also have the right to release of the seized goods. Okay, but there are some challenges like the implementation issue. Only 17 states have the grievance committee, and the town vending committees are either not formed or they lack representation. Also, the 2.5 limit is insufficient for large cities. So what is the way forward? We can revise the ceiling limits and establish vending zones. Okay, and welfare measures can be issue smart cards to vendors, train police and local, just get some civic sense, all of that. Okay. Now, what becomes important for you is all these minute details, okay, about the TVC and the COV, this limit. Okay. What else is important, guys? The PM Swanidhi scheme. Okay. So this was a microcredit scheme, right? So read about this. This also becomes important. Okay. You could also read about smart city missions. Okay. Let us move forward now. Temple regulation in India. Why was it in news? Because the Karnataka Legislative Assembly passed the Karnataka Religious Institutions and Charitable Endowments Amendment Bill to regulate temples in the state. Okay. So, what are the key features of this particular bill? Is that it amends the Karnataka Religious Institutions and Charitable. Okay, first of all, this. And secondly, the government will collect 10% of the income from temples earning over 1 crore annually and 5% from temples earning 10 lakh to 1 crore annually. So this is important. What it does, this particular act, is that first of all, it has it has paved a way for state intervention. Okay. And in that, suppose a temple earns rupees 1 crore, okay, over 1 crore, so greater than 1 crore, so the state will get 10% of this. Okay. And if the temple earns 10 lakhs to 1 crore, the state will get 5% of this. And where is this fund going to be used? It will be used for priest welfare, development of temples with income below 5 lakhs. Okay. So how is this possible? Can there be a state intervention in with respect to temples? So yes, it is possible, because in Article 25, freedom of religion, it allows state intervention in religious institutions, in particular Article 25 clause 2. Okay. The Article 26 grants religious groups the right to manage their affairs. Article 28 list entry 28 list 3 of the concurrent list empowers both the center and the state to legislate on religious endowments. And the Hindu religious and charitable endowments, this particular act is in various states to regulate temple regulation. Jaise it is also present in the Tamil Nadu state. Okay. We have seen temple regulation in colonial India as well. The Religious Endowment Act in 1863, which established local temple management committees. Then the Madras Hindu Religious Endowments Act 1925, which created a board of commissioners to oversee temples. The Hindu Religious Endowment Commission 1960, which justified government control over temples to prevent mismanagement. Okay. So here there are some arguments for why it is necessary, the state intervention, and why it shouldn't be done. So why it is necessary? Because it ensures social reform, ending hereditary priesthood. It encourages marginalized representation and prevents mismanagement, funds misuse. It uses temple revenue for community welfare. And why it is against it? Because it violates secularism, as other religions are not regulated. And the operational autonomy of temples is reduced. Also, it leads to poor conservation of temple heritage. The temple funds are diverted away from religious purposes. Okay. So why is this important for prelims? Is that this particular act Article 25(2). So give a read about that. You could also get a question ki which article allows states to regulate religious institutions, not just straightforward like this, but in some form you might get. Okay, so article 25(2) in particular allows for this. Also, the religious rights and the minority institutions, that fundamental rights, that also becomes important. So article 25 to 30. Also give a read to the state HR and CE, Charitable Endowments Acts. Okay, in Tamil Nadu, Karnataka, all these. Okay, models. We'll move on to the next subtopic. The Cinematograph Certification Rules 2024. Why was it in news? Because the Ministry of Information and Broadcasting notified the Cinematograph Certification Rules 2024, replacing the Cinematograph Certification Rules of 1983. So the Cinematograph Act was actually amended in 2023, of which the rules have been notified in 2024. Okay. So what is the key aspects of certification, of film certification in India? So the CBFC, the Central Board of Film Certification, is a statutory body which regulates public exhibition of films. Okay, when you talk about public exhibition, it also means theaters as well as your televisions. The CBFC operates under the cinematograph, as we know that it is a statutory body with 9 regional offices. The Supreme Court's ruling in S. Rangarajan versus P. Jagjeevan Ram upheld prior film certification as necessary. So we know that there is a Supreme Court case also which tells that there should be certification before you show that film to public. So what are the key features of this 2024 rules? Is that there should be women's representation. 1/3 of the CBFC members must be women. And new age-based classification, the unrestricted with caution, the UA category should be subdivided further. Okay, with respect to age. Then we have perpetual validity. Film certificates no longer expire after 10 years. So earlier, what used to happen in the earlier rules, if a film gets certification of universal, unrestricted, then it used to get, it used to expire after 10 years. So now it is that they have perpetual validity. And recertification for TV. Only film certified as universal can be telecast without modifications. Okay, so if you want to showcase a film which has unrestricted with caution UA rating, then what you have to do, you have to modify this and you have to get recertified it from the CBFC, and only then it can be showed on the TV. Only universal movies can be shown, universal as in rated universal. Okay, only they can be shown without any modifications. So as we know that the Cinematograph Act was amended in 2023. So what were the key provisions? That anti-piracy measures. So unauthorized film recording and exhibition is now a punishable offense. So if sometimes we see that people go to the theaters and they record the movie and then it is put on some site. So that is now a punishable offense. Online piracy concerns. So the law does not effectively address foreign-based film privacy. Okay, also content regulation issues. OTT platforms remain outside of CBFC regulation. So who regulates the OTT platforms? Okay, the OTT regulation is done by IT rules of 2021. Okay, under the IT Act, which talks about the regulation of digital content. So this is also important. Let us move on to the next subtopic. The Post Office Act of 2023. Why was it in news? Because this act replaced the Indian Post Office Act of 1898, bringing major reforms in postal services. Okay, again, this was outdated. So, what are the key provisions? The Director General of Postal Services, the DGPS, heads India Post. Government retains power to intercept postal articles for state security. So anything that comes via post, any article, it can be intercepted, as in it can be inspected to make sure that it is in line with the state security, if it does not hamper the state security. Okay, so that the government retains power. Also, there is no penal provision as it was in the previous act. So unlike the previous law, this act does not impose any penalties on the post office. Also, the post offices now have exemption from liability. The post office cannot be sued for service failures unless specified. And now there is one more, is that abolition of centers exclusivity. So the center had exclusivity in terms of letters. Okay, in terms of letters, it was the previous act of 1898. It gave center the exclusive privilege of transmitting all letters by post from one place to another. So anyway, after the private courier system, after they came to rise in 1980s, so anyway people were using private couriers more than the post office, okay, than the Indian Post. So anyway, they had lost their power. So now this act has also got the private couriers under its purview. Okay, that's why this is important. Okay, with this we finish the important acts, bills, rules. Okay, now let us move on to the next topic: constitutional, statutory, and executive bodies. First one is the National Human Rights Commission. So why was it in news? Because the accreditation of NHRC. Who accredits the NHRC? It is this particular institute. What is this? The Global Alliance of National Human Rights Institutions. Okay, this has affiliations with the UN, so it is UN affiliated. Okay, so what this particular institution does is that it gives rating, okay, to the different NHRCs of different countries. So the NHRC of India has got A accreditation first time in 1999. Okay, in 2016 this accreditation was deferred by a year. Matlab, it was not given. Okay, 1 year it was skipped, after which it received an A rating in 2017 again. Okay, so basically from 1999 there was just one difference. 1 year it was skipped, which was 2016, and again in 2017 it was given A. However, in 2023, the accreditation of NHRCI was deferred. And so to 2023 plus 2024, these 2 years, it has been deferred for 2 consecutive years. Okay. And now what is the major difference? That A rating has gone. Okay. So A rating has been suspended for 2 consecutive years. That's why it is in news. So why is this, this rating important? Because if you don't have a rating, if our NHRC doesn't have a rating, it cannot represent our country at the UN Human Rights Council. Okay. Why is it important? Because with no rating, no representation at the UN Human Rights Council. Okay. Also, it cannot no vote and no position. It cannot even hold any governance position. So that's why it is important, the rating for us. Okay. And what are the principles of rating? So the principles of rating are Paris principles. So these are the principles of rating. So these are some of the principles, like mandate and competence, autonomy from government. They should be independent enough. Independence guaranteed by a statute or constitution. Pluralism, adequate resources, and adequate powers of investigation. So it is seen that the Indian NHRC is lacking in this. That's why this institute decided to suspend its rating. Okay, so this was the entire story behind it. So now let us do a little something about the NHRC. So what is NHRC? It is a statutory body. It is not constitutional. Okay, it is statutory because it is established under the Protection of Human Rights Act. Okay. The Protection of Human Rights Act defines human rights as the relating to life, liberty, equality, and dignity of the individual. Okay. So ये कहीं सुना सा लग रहा है because we also have it in terms of our fundamental rights. They are guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. Okay, but it is important to note that NHRC is a statutory body. Then what about the appointment? Chairperson and members of the commission are appointed by the President of India on recommendations of a committee. Committee में कौन है? It is headed by the PM and it consists of Speaker of Lok Sabha, Minister in charge of Ministry of Home Affairs and Leader of Opposition in Lok Sabha and Rajya Sabha and the Deputy Chairman of Rajya Sabha. Okay. What is the tenure? 3 years or 70 years, whichever is earlier. Removal. Both chairperson and members can be removed from the office by order of the president. Okay, what are the powers? The NHRC has the power of a civil court. Okay, जैसे कि they have summoning and enforcing the attendance, वो वाली power. Then they have discovery and production of any document, receiving evidence on affidavits, requisitioning and any public record, issuing commissions. Okay, so civil court के जो भी powers होते हैं, they have the same powers. Okay, what are the functions? Now basically human rights violation में they can either do suo moto action or by the petition of a victim. Okay, you can read this for your understanding. Why is it important, guys? This particular act is important. It was asked in your PYQs also. Okay. So give a read about the Protection of Human Rights Act. Fundamental rights goes without saying. Also NHRC and SHRC about this also. Okay, let us move on to the next topic now. Central Bureau of Investigation, CBI. So why was it in news? The Supreme Court has upheld the maintainability of the West Bengal government's case against the Union government over the registration and investigation of cases by CBI, despite the state withdrawing the general consent in 2018. So what has happened? Okay, just to tell you in the form of a story again, the West Bengal government had filed a case against the Union government. Okay, because the CBI was still registering and investigating cases in the state, even though the West Bengal government had withdrawn their general consent. So what is this general consent, guys? General consent as in the CBI can only investigate with consent. Okay. Then there are different kinds of consents. First is the general consent. General consent as in some states have granted general consent allowing CBI to investigate cases without prior approval. So once, suppose I am state, I'm the government or whatever of state A, and somebody else is the government of state B. So what I do, I give my general consent. So now everything, any crime that happens in my state, the CBI can come and investigate it if it is of that importance. Okay, so they don't need to ask for every case ki karu kya. They don't have to ask that. Okay, but the state B decides that they will give only specific consent. So what is that specific consent? If you withdraw your general consent, the CBI must ask permission from the state for each case. Okay, suppose one case has happened, this particular case X has happened, and the CBI wants to investigate on that, they should first ask seek the permission of this state B government. Okay, so what the West Bengal government had done, they had withdrawn their general consent. Matlab what they are having now, they have specific consent. Okay, but despite withdrawing the general consent, the CBI was still registering and investigating cases in the state. Okay. Now, why did the Supreme Court get involved in this? This is a very important part of your prelims now, because if there is a question of argument between the center and any state, then who comes into picture? Whose original jurisdiction is that? Okay, it is the Supreme Court's original jurisdiction under the Article 131. Okay, very important. Okay, so now Supreme Court has not given, it has not taken any side. Okay, Supreme Court only agreed that West Bengal's case was valid and it could be heard. Okay, that's all. So Supreme Court has not given a decision. It has just upheld the maintainability of the case. So the case was filed under Article 131, which grants the Supreme Court original jurisdiction in disputes between the center and states. So this was the entire story of this. Now about CBI. So CBI was established in 1963 on the recommendation of the Santhanam Committee on Prevention of Corruption. So under which ministry? It functions under the Ministry of Personnel, Pension and Public grievances. But it is not a statutory body. It is non-statutory. It is non-constitutional body. It is governed by the DSPE, which is the Delhi Special Police Establishment Act. Okay, very important. It is not statutory. It is not constitutional, but it is governed by the DSPE Act. What are its functions? It is the premier investigative agency handling anti-corruption, economic offenses, special crimes, etc. So it is headed by a director. It is assisted by, yes. Okay. It is headed by a director. It is assisted by a special director, additional directors, joint directors, deputy inspector generals, and superintendents of police. Okay, so this is their structure, formation. So what are the key judgments, okay, with respect to the CBI? Common Cause versus Union of India. In this, SC ruled that the CBI director must be appointed by a high-level committee comprising the PM, leader of opposition in Lok Sabha, and the Chief Justice of India or his nominee. Then CBI versus Dr. R.R. Kishore in 2023, wherein the SC ruled that its earlier 2014 judgment, striking down the section 6A of the DPSC Act will have retrospective effect, meaning section A has now been invalid. Okay, the Vinit Narayan versus Union of India, it is known as the Jain Hawala case. SC struck down a 1969 directive restricting CBI's ability to probe senior bureaucrats without government approval. Okay, so this particular case is important because it gives the special power as in the autonomy to CBI. Okay, what becomes important, guys? This case, autonomy to CBI, also the articles that we talked about. Suppose you get a question saying under which article the Supreme Court has original jurisdiction in center and state disputes. Okay, then you get 4 options. Article 143, Article 32, Article 131, Article 226. What is the correct answer of this? Yes, anybody can answer. The correct answer is Article 131. Okay. The CBI operates under which law, guys? Which law does it operate under? It operates under the DPSC, Delhi Special Police Establishment Act. Okay, but it's a non-statutory. Can you please mute, dear, whoever it is? Okay, so this forms the important part of your prelims preparation, guys. Okay, we'll do the rest of the things in the next class tomorrow. Any doubts, anyone?
No, ma'am.
Okay, so thank you for this, guys. Thank you for being with me. Thank you for watching this video. If you like this initiative,
Thank you, ma'am.
please like this video, subscribe to our YouTube channel. Also share this with your friends who are preparing for UPSC prelims. You can find the PDF of this particular magazine in our Telegram channel. Okay, the link will be provided.
Okay, ma'am. Thank you.